Thank you very much for those generous introductions. I have to confess that I no longer play squash at all, but it was a passion at the time. Distinguished guests, it's a huge privilege to be invited to deliver the annual lecture in honour of Lord MacDermott. I've developed a real affection for this jurisdiction and for the bar and judiciary here on the many occasions when I've been invited over. And it's a real pleasure to deliver a lecture to honour one of the giants, the greats of this jurisdiction, a real legal giant, having held so many positions of high office. His judgments as Lord Chief Justice, but also as a law lord and Privy Councillor, continue to bear testimony to his legal skills, to his legal expertise. I confess I hadn't really appreciated how much until I started researching how many of his judgments continued to represent seminal statements of the law on areas as diverse as child law, the definition, for example, of perverting the course of justice, and so on. So it really is a true privilege, as I say. And in one sense, in my wildest dreams when I envisaged sitting there in the Supreme Court, I think about people like him and Lord Denning, who then went even beyond their wildest dreams by going back to the Court of Appeal, because there must be more fun to be had, and I look to the Lord Chief Justice here, there must be more fun to be had in the Court of Appeal, where you can deal with more cases and meddle more in the law than in the rarefied atmosphere of the Supreme Court, or then as it was, the House of Lords. Talking of the wildest dreams, it reminds me of that anecdote of somebody about to deliver a very prestigious lecture such as this, and he's overawed by the circumstances, and he rings home to his spouse and says, this is amazing, I've been asked to give this the most prestigious lecture. In your wildest dreams, did you ever see me delivering this lecture? And his spouse says, in my wildest dreams, I don't see you at all. So, to more pertinent matters. I've chosen a topic which is as controversial as can be, so I have to immediately issue two disclaimers. First of all, I'm speaking this evening in my personal capacity and not as Law Commissioner, because the Law Commission's recommendations on joint enterprise have now been superseded somewhat, and we don't have an official policy statement on the case, the Joji case that I'm going to speak about. The other is that the decision is now subject to a retrial. The case involving Mr. Joji is now subject to retrial, so I have to be rather cautious about what I say, lest any jurors in the Midlands in England and Wales are likely to be tuning in, and I might influence their decision. I would hate to commit contempt, although I would seek to inveigle the Lord Chief Justice and Attorney General's presence here as some kind of defence. So the decision that I want to focus on, although the topic is the rise and fall, obviously it's much more interesting to focus on the fall of anybody or anything. I want to focus on that decision in Joji. I want to explain how we came to have the position where that decision was necessary, and also to unpick some of the problems that perhaps that decision has left unresolved. And perhaps it was a surprise to the Supreme Court when they handed down that unanimous decision, conjoined with an appeal in the Privy Council, that it would attract so many headlines. Not necessarily the kinds of headlines that Supreme Court justices would be used to. And as ever, it's much more interesting if you scan down and read the comments of what people actually think about the Supreme Court justices. But perhaps not such a surprise when you consider that joint enterprise was a doctrine that impacted on homicide trials involving groups of individuals, or in the more colourful language of the press, gang murders. Of course, that's going to be of interest to the general public. And the question at the heart of the appeal in Joji and at the heart of this lecture is where the boundary of the offence of murder should be drawn when somebody has not personally committed the act of killing and has perhaps not even directly assisted or encouraged in that killing. That's an issue that's troubled academics, policymakers, judges, practitioners, and of course the general public, not only in England and Wales, but in this jurisdiction for decades, indeed for centuries. If you read the decision of the Supreme Court, they cite cases dating back to 1672 where highwaymen were dividing their work between them and whether or not liability could be imposed between them. One of the decisions that really in the last, or in modern history has triggered this debate is a decision shortly after Lord MacDermott was in the House of Lords. In 1953, in the case of Davis and the DPP, the House of Lords really set running this debate about the boundary of the offence of homicide. It captures the very essence of the problem. Half a dozen youths engaged in a fistfight on Clapham Common in London. One of their number pulls a knife and stabs one of the opposing gang. Is the liability for murder to extend beyond the stabber to those also party to his gang? And the then Lord Chancellor set out his view. There's no reason why, he said, if when half a dozen boys fight another crowd, the rest of the killer's group should be treated as accomplices unless, and then for the last 60 years we've been toying with the unless. Is it sufficient or necessary that the parties other than the stabber have themselves intended that the victim be killed with a knife or attacked with a knife? Is it sufficient that they have acted in concert, or is it sufficient that they have contemplated an attack? Is your contemplation of a murder being committed by somebody else sufficient to saddle you with liability for murder yourself? And that is the doctrine of joint enterprise that has caused so many issues. To move to the old law, if I can call it that, and its evolution, the law prior to the decision of the Supreme Court in Joji earlier this year, I want to explain in as short a time period as I can quite a complicated doctrine, and I'm conscious that not all of you will be criminal lawyers or necessarily lawyers. So I will try to make this as painless as I can, but there's a serious point behind that, which is, in my trying to make it painless, bear in mind the difficulty that members of the judiciary faced when they had to make this painless to juries week in and week out. So the old law was as follows. The defendant is clearly liable as a principal offender if he commits the offence in person. Well, that's uncontroversial. You've taken responsibility for your actions. If you've stabbed somebody, quite appropriate that you be treated as a murderer. Equally uncontroversial in this jurisdiction and in England and Wales and in most other common law jurisdictions, that if you aid, abet, counsel or procure, we can ignore the arcane language, if you assist or encourage somebody, then you should also be liable for the act you've assisted or encouraged. And what's interesting about English law is, and indeed Northern Irish law, is that the liability of that secondary party, D as I've labelled him and will in the slides throughout, the secondary party, the assister, is labelled in the same way as the principal, is convicted, is processed, is charged, convicted and sentenced in the same way as the principal. So to take a rather simple example, the person who burgles the house, trespasses with intent to steal and so on, is guilty of burglary. The person who assists by driving the getaway car, by giving him the code for the alarm on the house or whatever it may be, is also liable under that second bullet point, and his liability is as a burglar. He is labelled as burglar, charged as burglar, convicted as burglar and sentenced. There may be a disparity. If he's only been the getaway driver, it may be that his ultimate penalty is reduced. Nevertheless, he is saddled with the same liability. And that doctrine was uncontroversial for centuries. The controversy arises in relation to the extension of that doctrine in this third bullet point, whereas the central bullet point there, the middle ground, often described as plain vanilla liability, secondary liability. Well, if we make it more spicy, the defendant who is involved in that burglary, perhaps he's the getaway driver, well, he becomes liable for any other crimes committed in the course of that burglary that he has foreseen. So just going back to our simple example, I decide that I will help you in your burglary of the rival drug gang's den across town. I will act as the getaway driver. You will go into the den, you will steal the drugs, you will come back to the car, we will drive home. Off we go. You are, of course, disturbed in the course of the burglary and you commit a murder. My liability for the burglary is pretty simple. I'm the getaway driver to the burglary. That's what I'd envisaged. That's what I'd intended all along. That was our joint common purpose. And quite rightly, I should be held liable for that. The question in debate over the last decades and for debate in the Supreme Court in the Joji case was the extent of my liability for murder. If I have only foreseen as a possibility that you might commit murder in the course of that burglary, should I nevertheless be guilty of murder? This is not the case where I have intended that you go to kill. Yes, let's go and raid the rival drug gang's den, and while you're there, look for anybody you can find on the premises and kill them. Well, that would, again, be a pretty clear case making me suitably liable for murder. We're not in that territory. We're in the hinterland where my liability turns on me seeing while I'm driving the getaway car, well, I wonder what will happen if somebody is in the premises. I wonder what will happen if there is a challenge made to the principal who's going to go in and steal the drugs. I know he's hot-headed. I've been a member of his gang for a long time. I know he usually carries a knife. In those circumstances, is that combination of knowledge, that foresight, that jigsaw that I'm putting together in my mind sufficient to impose liability for murder? And following a succession of cases in the 1980s and, well, actually through the 1960s up to the 1980s, the answer came back yes. I would be liable as a murderer in those circumstances, adopting the so-called joint enterprise principle, and these are the criteria. To be guilty of that murder, I have to have participated with the principal in the commission of the crime, burglary, either by taking part in the burglary myself or by assisting it or encouraging it. I have to have shared a common purpose with the principal to commit the burglary. This is our primary aim. The murder must, of course, have occurred in the course of the burglary. That seems like an obvious point to make, but it has been overlooked by several judges in summing things up. All of that is a sufficient foundation under the joint enterprise doctrine to render me liable for murder, provided I foresaw the possibility that you might kill or cause grievous bodily harm with intent. I have to foresee that you might at least cause intentional grievous bodily harm. And there's an escape clause in there that I have foreseen that you might commit this kind of offence, and the manner of your commission of that offence is not fundamentally different. So I foresee that you might commit murder in the course of your raid on the rival drug gang's den. What I didn't foresee is that you would take along a submachine gun and kill as many people in the vicinity as you possibly could. Something in a totally different league that would render me merely part of the background, take me out of the equation. So in those circumstances, provided I haven't withdrawn, I haven't said, actually, now that I've thought about this and I've realised there's a risk that you're going to murder, I'm no longer playing ball in the burglary. Provided I haven't taken that stance, then I become liable for the murder itself. Just as an extreme example of this, what we're doing is we're constructing liability for murder, crime B, on the basis of my commission of crime A, burglary, with foresight that you might commit crime B. Take the case of Daly, which was decided shortly before the decision of the Supreme Court, which allowed the Court of Appeal perhaps to answer that they would just wait and see. They said, well, we're applying established doctrine of 30, 40 years here. We will wait to see what the Supreme Court does. The defendant there in this case got into the car with the principal having a firearm in the vehicle. So they're both now committing an offence. They are in joint possession of a firearm in a public place. Any number of criminal offences, members of the bar here I can see are churning through the firearms legislation, working out how many offences that might constitute. In the course of their driving around, the principal then shoots somebody. The person who was originally in the car shoots somebody. Does that make his passenger guilty of murder? Well, the Court of Appeal said it did, if he either killed himself, which he didn't, or he'd encouraged the shooting, he sat in the passenger seat saying, let him have it, or whatever it may be, or, under our controversial doctrine, he participated in the possession offence. He was in the vehicle with the principal, committing the offence of possession of a firearm, and he foresaw the possibility that the driver might commit a murder if the opportunity arose. Perhaps an extreme example, but as I say, a very recent one. And that all follows from the decision which has now been regarded as erroneous, the decision of the Privy Council, the opinion of the board being given back in 1985 by Sir Robin Cook. This is a case where the three appellants in this case had each armed themselves with a knife, and they'd visited a flat in which a prostitute lived, and the husband was habitually there. Their intention was to rob the husband of the takings, and when they were challenged, they killed him and injured the wife. They were all convicted of murder, and they challenged the judicial direction, which had been along the lines that I've just described to you, that it was sufficient that they had contemplated that the person with the knife might use it if it became necessary to do so. So the doctrine of joint enterprise, and as you can see there from the extract that I've put up from Sir Robin Cook's judgment, or opinion I should say, in the board, it's sufficient to make them liable for the murder that they have contemplated or authorised the activity of the principal by going along with it. So they've gone along on a robbery or a burglary, and they have in doing so foreseen or authorised the murder. That's the controversial doctrine now, as I say, regarded as erroneous by the Supreme Court. There are several problems here, not least that there was a very ambiguous theoretical foundation for the doctrine. We're extending the boundary of the law of murder, but it was never really made clear on what basis. Even within that passage in the seminal judgment, we have both contemplation and authorization used as the foundation for liability, but they're very different. Saying that you have foreseen something, even saying that you've foreseen something and gone along with it, is not really a common way of describing something that you have authorised. You would usually expect there to be a greater degree of endorsement, a more explicit degree of endorsement, before one could say that it had been authorised. Some have suggested, and I'm corrupting acres of academic text here, the number of articles on joint enterprise, its foundation, its failings, and so on. They're in as many journals as there are in print over the last decade or so. Everybody having their own theory, their pet theory on how liability in the Chang Wing Sui case, in the Daly case, might be justified. Perhaps some said it's based on tacit agreement. You could say that by going along on this raid of our rival drug gang's den, I have tacitly agreed that if you need to use force, if you need to use intentional grievous bodily harm, force of that level, then I have in fact authorised it, sanctioned it, I'm committed to it, I'm endorsing it. It justifies my liability. But again, there's a long way, it seems, between foreseeing something and tacitly agreeing it. It may be that liability would arise, and it's clear from the case law prior to Joji that it would arise, if on our way to the rival drug gang's den, I'd said, I know that you often carry a knife, you must not use the knife. I'm going to continue to drive you there. I want you to burgle the premises. I need the stash of drugs. We need it as a gang because we need to sell them, but you must not kill anybody. If I said that, but nevertheless continued and drove the principal there, knowing that he continued to possess that knife, I would have been liable prior to Joji. So to suggest that there's tacit agreement when it's the very thing that I have expressly prohibited the principal from performing is a straining of the words. It wasn't even clear, if you look back to that language in Chang Wing Sui, whether liability was regarded as a cap whether we were saying that somebody was liable for every offence that arose in the course of the commission of the crime that they'd agreed on, burglary. You're liable for every offence that any member of the burgling party commits, provided you've foreseen it. Now, does that operate as an inclusionary doctrine or as an exclusionary doctrine? Is it saying you're liable for all offences, but we will limit it to those that you've foreseen? Or is it saying that you're liable for everything? Never really clearly expressed by the courts. Nor was it expressed properly as a doctrine of agency, although several lawyers, several very eminent civil lawyers sitting in the Court of Appeal, always a danger, sitting in the Court of Appeal Criminal Division in England and Wales, sought to justify it by some kind of agency principle, but that doesn't really sit comfortably either, because with a normal civil doctrine of agency, the agent is saddling his principal with liability, whereas here it's the exact opposite. The principal is saddling the accessory with responsibility. So very unclear. It was really a matter of policy, and that was acknowledged by Lord Steyne in one of the leading House of Lords authorities as the doctrine became embedded. Subsequently to the decision of the Privy Council in Chan Wing Sui, a number of decisions of the House of Lords and the Court of Appeal Criminal Division endorsing what was said in Chan Wing Sui, including most famously in Powell and Daniels, where Lord Steyne said, this is about deterrence. It's about the crime control function. There is evidence that gang activity, mob activity, escalates. When you have one person acting independently, then that might or might not lead to a criminal offence being committed. The more people involved, the more they are likely to encourage each other, the more their daring will stick, the more they will perpetrate and fulfil their plans. So that was the true basis, perhaps, this policy. And despite repeated challenges to this, including one in the famous case of Ganango back in 2011, the Supreme Court kept upholding, House of Lords and Supreme Court kept upholding the doctrine. Ganango is one that you've probably come across because of the fact pattern so unusual. The defendants had met in a South London car park to have a duel almost. They were shooting at each other across an open car park. I shoot at you, you shoot back. Tragically, you miss me, and you kill an innocent bystander walking across the car park behind me. Well, you're clearly guilty of murder on the basis of your shot having killed that individual. If you could be found, in this case, it wasn't possible to find the person who'd pulled the trigger. The question for the Supreme Court was whether I was liable for the murder of the person behind me on the basis that I had encouraged you, I had taken part in an activity where we had both encouraged each other to shoot at each other, and whether I could be liable on that basis. A 5-member Court of Appeal said not, and a 7-member Supreme Court reinstated the murder conviction. I have to say, and not just because I'm in this jurisdiction, that the best judgment in that decision is that of Lord Kerr in dissent. Whenever undergraduates used to ask me, they won't anymore, how do I understand joint enterprise, how do I understand the law, I always used to say, just read the dissent. It's not the law, but it will expose to you all of the flaws in the law. But the majority, the 6 in the majority, acknowledged the joint enterprise liability, the parasitic accessorial liability principle as it became known. So rather than plain vanilla liability, which is where you've just got the one crime, I go along with you and I assist you in the commission of the burglary, plain vanilla, basic accessory liability. This is where I have assisted you in a second crime, the murder, and hence the label parasitic accessory liability. I can't blame the Supreme Court for that. In fact, the language was that of the great Sir John Smith. And in fact, I was at that lecture, I remember it well, when he used that in 1997, I think it was. It's a very long time ago. So let's have a look at some of the problems. We've established that over the 40 years or so, there became embedded this doctrine of joint enterprise or parasitic accessory liability, if you prefer. What are the problems it posed? Well, they were substantial. The principal problem of principle was that we seem to have diluted the degree of fault required for murder. Somebody could be guilty of murder on the basis not of an intention to kill or an intention to do grievous bodily harm, but simply the foresight of what somebody else might do. To take an example, an individual who sets out to conduct a punishment beating might desperately intend that the victim survives. If the victim dies, they can still be guilty of murder because they have intended grievous bodily harm. And it's right that murder should extend beyond intending to kill in circumstances such as that, although that's a controversial doctrine in itself. But it's right that the opportunity for a murder conviction arises where somebody has intended very serious harm, such as that, and has been reckless as to the threat to life. But this is going well beyond that. This is not just somebody intending grievous bodily harm. This is somebody foreseeing that somebody else might commit grievous bodily harm. Now, as I said earlier, because we don't have a strong theoretical foundation for that doctrine, it's difficult really to defend it. And people sought to do so by saying that you had wedded yourself, I had wedded myself to this enterprise, I'd endorsed it, I'd authorised it, I'd agreed to it by going along on the burglary, and in doing so I have to take responsibility for all of the consequences. But that just doesn't sit comfortably with the rest of the criminal law. As I've said on the slide, what moral principle demands that I take responsibility, not for my choices, but for somebody else's choices that I have foreseen, not for the choices that I've authorised, that I've gone along with the burglary. Yes, I'm coming along with you to commit a burglary. I know the full scope of my liability for that because I am participating in that burglary, the plain vanilla burglary. This is different. I am being held liable here for an activity which at most I have foreseen. Not necessarily at most. I have foreseen that it might occur. But it all turns on your choices in the future, which are entirely beyond my control. Going back to my factual example, I'm in the car. I'm outside the drug dealer's den. I'm revving the engine waiting to do the drive to get us away. I have no control over you at that point, and yet I'm being held liable for the murderous choices you make when you are in the den. And I can really only be held to be liable there on the basis that I've somehow constructively encouraged or assisted you to do so. There were really significant problems of principle. There were many practical problems, many of a degree of ambiguity. Why should it be that the crime that we first set out to commit is one that we share a common purpose to commit? Must I foresee the whole of the principal's crime, or is it sufficient that I foresee only the actions that the principal might commit? I'm going to press through these quite quickly because they're now all historic problems, thanks to the decision of the Supreme Court. But just to emphasise how many problems arising from the ambiguity there were. It wasn't clear, in other words, on that second bullet point, whether I had to foresee that you would kill or that you would cause grievous bodily harm. Even the Supreme Court in the Ganango case left that unanswered, it seemed. As a result of that lack of clarity, that ambiguity, the judicial directions on joint enterprise were complex and technical, and despite these being conducted by judges of the highest calibre, murder-ticketed judges with the assistance of the highest calibre counsel, leading counsel, with routes to verdict, written directions to assist jurors, things were missed. If you look to the volume of appeals in the Court of Appeal Criminal Division, it's obvious how complicated these things are. And the routes to verdict is something I just want to mention as a really important development, something that I've been particularly proud to have taken part in with my work for the Judicial College in England and Wales, producing the bench books by which judges now routinely direct juries. We did some work along with Cheryl Thomas, my colleague at University College London, to identify the success, how much routes to verdict, how much written directions would assist jurors. Rather than you all having to sit there and listen as you're all doing intently now, with no paper in front of you, no structure, no framework, how much better it would be if I'd given you all a handout so you could follow what I was about to say. Well, the same with jurors. My analogy that I often use on this is contemplate a situation where a group of people who have no medical training are invited to attend a lecture in the medical school, and they're told only that at the end of their lecture in the medical school they will be asked to decide whether or not a patient put before them requires an operation or not on the particular topic about which they're to be lectured. Who will perform better? The group of erstwhile students who sit there with no document, no framework, no handout, no guidance, no PowerPoint, who just sit and listen for an hour and then are asked the question, well, do you think the operation should take place or not? Or the group who've been told, here's the handout, these are the structured questions through which we're going to work as we decide on the correct diagnosis of the patient. It's a pretty obvious answer, I think. But the empirical work with jurors conducted by Cheryl Thomas bears it out. She did empirical research, as I say, with live jurors, real jurors, not mock jurors, and the results were astonishing. 100% of those who had been given written directions said that they'd found them valuable. That's unheard of in empirical terms. You don't get 100% results. It's something rather fishy, you think, if you get 100%. But perhaps even more astonishing, 85% of those jurors who hadn't been given the written directions said they would have liked them. Well, that's also suspicious. If you're being asked whether you'd like something that you've never had, you would expect a degree of caution. But this is really illustrative of the fact that jurors want help. And in a case like this, in a situation like this, of course they want the guidance, taking them through the questions that will help them conduct that diagnosis at the end. The complexity, the ambiguity, all led, of course, to more trials. That was also as a result, I think, of the fact that the breadth of the doctrine meant that prosecutors were able to charge more people from the same incident. One famous incident in London, no fewer than, I think, 20 people were ultimately charged with murder as a result of one incident. A series of conjoined or linked trials then occurred. So you get very large numbers of defendants. And because of the gravity of the penalty, because there's a mandatory life sentence for murder, there's very little incentive to plead. The discount for a plea of guilty in a murder is capped, so there's no incentive to plead. So you end up with more people going to trial, fewer pleas, longer trials, more complexity, more difficult to manage for the trial judges, more likelihood of error, more appeals as a result, an altogether unsatisfactory position. Not least as well because of the cost, enormous cost, not just in terms of finance, but the knock-on effect to trial timetables. But there were broader policy concerns as well. And the fascinating work by Ben Crew and Alison Liebling at Cambridge, which was published in the Criminal Law Review last year, brings this to the fore. Those who were convicted as joint enterprise murderers were embittered within the criminal justice system. Now, that might not sound surprising. You've just been convicted of murder. Of course you're going to be unhappy. But in the way that their research has demonstrated, those who've been convicted of murder commonly come to terms with that fact and the label that's been ascribed to them after a period of time. Not so, or certainly not so to the same degree with those convicted under the joint enterprise doctrine. They resented the fact that they had been labelled as murderers when they perceived themselves not to be murderers. This meant that they were, as I say, embittered. They disengaged with the prison establishment, with the prison service. That makes it much more difficult to manage. And more disturbingly, perhaps, if you look to the evidence of the impact this had in racial terms, again drawing on the research here, this is quoting from the Crew and Liebling work in the Criminal Law Review, a disproportionate number of those serving sentences were minority ethnic community and Muslim in England and Wales. It seemed to have a disproportionate impact on those in young black males, in particular in urban centres in England and Wales. And you might say, well, of course the convicted murderer is going to say that there's a misperception of his label, a misperception of his wrongdoing. But that was also borne out by public perception. Some interesting work done by Barry Mitchell at Coventry University and Julian Roberts at Oxford, where they, in a Nuffield-sponsored survey, did research to ascertain the general public's attitude to life imprisonment, sentences of life imprisonment. And they concluded from their research, it's fascinating research, they put different scenarios to the general public. They concluded that actually the public don't support a mandatory life sentence in all types of murder. They do have confidence in judges to approach sentencing in a discretionary manner appropriately. And in relation to, that's the title of the research, in case anybody's interested in finding it, you can just Google it and it will no doubt come up. In relation to the joint enterprise case, they put to individuals these two scenarios. Now, first thing this morning, I was at the International Advocacy Training Council conference, and the first rule of advocacy is that you never ask a question to which you don't know the answer, but I'm just going to throw that away, and I'm going to say, for those of you present, how many of you in case A would be content for Pete, the non-stabber, how many of you think it is appropriate that Pete is found guilty of murder? And how many of you think he's guilty of manslaughter? I can't ask two questions. How many of you think he should be guilty of murder? And how many of manslaughter? Okay. And in the second category, Mike has a loaded gun, a spelling mistake there. This is Bob, the getaway driver. How many think he's guilty of murder? Armed robbery, he knows he's got a gun, he drives him there, but he's not the shooter. How many think that the getaway driver should be guilty of murder? Okay, very interesting. The opinion on the Nuffield survey was as follows. In the Pete case, only 21% of people thought that he should be guilty of murder, and yet under the doctrine that I've described to you, he would have been guilty of murder. And 58% thought manslaughter was appropriate. And in Bob, not dissimilar. That was quite surprising to me. I thought more people would have thought Bob was a potential murderer. Anyway, really fascinating research on public attitudes. So there was real concern from the academic community, broader policy concerns, and this was picked up more broadly. You may have seen the influential and award-winning Jimmy McGovern drama Common, which is still available on the BBC website. And the work done by this campaign group, JENGBA, the Joint Enterprise Not Guilty by Association group, who were funding many of the appeals and who were very influential in getting the most high-profile cases into the public eye. So, problems of principle, problems of practice, broader policy issues, all of that seems to be a pretty compelling case for reform. And just to cap all of that, if we think about the scale of the problem, some work done by the Bureau of Investigative Journalism found that around 70% of all homicide trials involved a joint enterprise, and the figures in terms of numbers are again very high. 1,800 prosecutions where there were 4 or more defendants, 4,000 where there were 2 or more, which if we just focus on that third bullet point, up to 40% of all homicide trials taking place then in England and Wales were joint enterprise, potentially joint enterprise cases at one time. A huge number. So the momentum for reform was striking. The Law Commission had looked at this, as you would imagine. A responsible body in 2007 had put forward very strong recommendations, and they had not been taken forward by successive governments of different political hues. The government inertia was perhaps surprising beyond that because, well, it's one thing for them to ignore scholarly musings and perhaps even campaigns from pressure groups. It's even more surprising when they ignore the calls from their own committees. And in 2012, the Justice Committee in the House of Commons called for the government to act by reconsidering the Law Commission recommendations. And again in 2014, because in 2012 the government refused to do so, declined to do so, in 2014 the committee again considered the scope for reform, and they concluded that although the Law Commission recommendations had now really been superseded, there was a very good case for urgent review. They called for an urgent Law Commission review to report by the end of 2015. The government declined at that time because there was an election pending and it would not have been appropriate. But the Justice Committee was pretty forceful in saying that they thought the Chang Wing Sui principle was wrong, and that it was time for a full Law Commission review. So the scene was set. There was inertia in government. There was this great public perception of misconduct, of wrongdoing or injustice. Was it going to be brought about by the Supreme Court? Well, that was a difficult question. Chan had been endorsed by the Supreme Court, by the House of Lords, repeatedly, as recently as by a 7-member Supreme Court, subject to that very important dissent, in 2011. And the Supreme Court had demonstrated a certain wariness, a certain caution, perhaps appropriately, of stepping into legislative shoes. You think to the cases on assisted suicide, for example, where they have been very careful to draw the line and say, this is a matter for Parliament, not for us to intervene. Well, here we've got a background where Parliament is saying repeatedly, we're not going to intervene. We're declining to take up the Justice Committee's invitation to review the law. Is it realistic to expect the Supreme Court to step into those shoes? Would the court take the lead when there was no appetite for legislation? Well, my former colleague William Wilson and I really threw down the gauntlet somewhat in 2015 by encouraging them to do just that, by saying the Supreme Court has all of the capacity to do this. They would be, we're confident, more than capable. A diplomat might say the quality of their final product compares favourably with some of the outpourings from Westminster in terms of the bill, in terms of its bills, and there's an opportunity. There are cases being appealed week on week to the Court of Appeal. You only need one of those to go to the Supreme Court. Much more likely that that opportunity to reform the law will arise than a government bill in a crowded legislative timetable. And I'm delighted to say that the Supreme Court took up that challenge in Joji and Ruddock in Privy Council, and they changed the law. Now, I'm going to run through what the change of the law is relatively quickly, because I want to be ungrateful and criticise it, which really is a bit ungrateful, isn't it? Having campaigned and been very vocal in suggesting that the law was operating unjustly, to then turn around and say, but the answer you've given us isn't quite the one that I'd hoped for, is perhaps ungrateful. But nevertheless, that's what academics and law reformers do. Otherwise, we'd be out of a job. So what's the new law? Well, the new law is really quite simple. We strike out that third category, that controversial category. No such thing as parasitic accessorial liability, or joint enterprise liability, if you will. If the defendant is to be liable, going back to my example of the burglary, if I'm to be liable for a murder committed by you when I've driven you to our rival's drug den and you go in there and you commit that murder, I can be liable only if I have intended that you would commit a murder, intended that you would kill or commit grievous bodily harm with intent. So the mere foresight, as a rule of law, it is no longer sufficient as a matter of substantive criminal law. It's no longer sufficient that I have foreseen that you might kill. So in short, this bottom paragraph there is the shift. The main shift then is that it was sufficient that I foresaw that you might intentionally kill or do grievous bodily harm, and now we have a requirement for proof that I knew or intended that you would. And at face value, that is a very marked change. It's a ratcheting up of the level of fault. It's a narrowing, in other words, of the scope of the offence of murder. And the Supreme Court's decision should be really welcomed, and I'm being sincere in that regard. It's clear, it's concise, and it establishes fundamental principles across the whole of the secondary liability area of law. So the questions about basic accessory liability, about plain vanilla accessory liability, as I've described it, are very clear. And I've tried to summarise them there, but they're rather boring statements of doctrinal criminal law, and they won't feature in anybody's undergraduate examination paper, so I'm going to press through them. The important point really is that the court has really synthesised the law. We have one set of principles. They're clear, they're fundamental, they're well established, and they are applicable universally across the secondary liability scheme. I'm going to just skip over those because I'm also conscious of the time. So we've shifted from a situation where it was sufficient for me to have foreseen that you might kill on our raid of the drug den for a requirement now that I have to have intended. And that's all good. Is it good? Well, let's consider the relative justice of the situation. We still have to prove that a murder occurred in the course of this raid on the drug den that I've described to you, although it remains the case that we don't have to prove who the murderer was. And this is a really litmus test for the potential relative justice of the change in law. So under the old law, in relation to, let's take a situation where 4 of us have gone to the rival drug gang's den, and we've all gone into the building, in fact, and it's clear from the aftermath that one person, one of the 4 of us, has killed somebody within that room, and they've done so with intention. It's obvious from the depth of the wound that it was an intentional killing. In relation to each defendant brought before the jury under the old law, the jury could have said, well, I cannot be satisfied beyond all reasonable doubt that this defendant was the stabber. But that's okay. I can be sure that he foresaw that one of his brethren, one of the other 3, might use intentional lethal force. So he's a murderer. Guilty. Next. Well, I can't be sure that you're the stabber, but I can be sure that you foresaw that one of the 3. We get to the end of the trial, all 4, or the jury deliberations, all 4 of them have been convicted of murder on the basis that each of them foresaw that somebody else was going to be a potential killer, might kill. That looks to be an injustice because it looks like 3 individuals there have been convicted of murder when perhaps, certainly applying the new law, they would be more likely to be convicted of manslaughter because they had something less than an intention. Now, if we compare that with the new law, we have the same scenario. Individual brought before the jury and say, well, I can't be sure that you're the stabber, but what I can be sure of is that you intended that one of the other group, one of your gang of 3, the other gang members, would kill. I'm sure that you intended. We'd get to the end of the deliberations, and if the jury was satisfied that all 4 had the intention, they'd be guilty of murder. But if they weren't sure of that, if they were sure only that, as under the old law, that each of them had foresight, then they would be guilty of manslaughter. So we've had a dramatic shift. Under the old law, 4 murders. Under the new law, at face value, it seems, 4 manslaughters. Well, that might seem uncomfortable to some people because nobody in that scenario is being convicted of murder. And this was one of the real sticking points for reform. People couldn't tolerate the idea that you would have a group killing of that nature where somebody had intentionally killed and yet all of the individuals would be convicted of manslaughter only. But if we think about this in terms of relative justice, in the first scenario, the old law, we had 3 injustices because 3 people who ought to have been convicted of manslaughter, as we're now told, were convicted of murder. Under the new law, where all of them are convicted of manslaughter, we have 1 injustice. Somebody has escaped his just deserts. He should have been a murderer, and he's been convicted only of manslaughter. So in relative terms, we had 3 that were elevated to murder. Now we have 1 who's been lucky in escaping a murder conviction, but has been convicted of manslaughter. And you can make an argument, as I tried to do last year, on sort of Blackstone principles, that better that 10 guilty men go free and so on, and say, well, better that there is an injustice the wrong way, better that there's an injustice diminishing liability. But that slide assumes that intention, as the law now requires, is going to be faithfully applied. In the next few minutes, I just want to tease out some potential problems. When you look at the decision in Joji, it doesn't stop by saying the defendant, me in my example, I have to have intended that the principal will go on and commit murder in the course of that drug den raid. The Supreme Court goes on to say that it is possible for the jury to be satisfied that I intended provided I foresaw it. So whereas under the old law, foresight that the person I've driven to the scene of the murder would be sufficient, foresight of his intention or GBH would be sufficient as a matter of law. Now it's a matter of evidence. The defendant, in my example myself, I would have to be proved to have intended that the person I've driven to the scene of the crime would intentionally cause grievous bodily harm or kill, but the jury can find that intention, they can infer that intention from my foresight. So what's happened is we've moved from substantive law to evidence. Well, how much of a change is that? And is there an imbalance, an incoherence here with the law of murder? Throughout the 1970s and 1980s, the House of Lords struggled with the concept of intention in the crime of murder. It's clear that somebody whose purpose is to kill or cause grievous bodily harm is going to be guilty of murder. But what about the character who would rather it didn't happen, but they've foreseen it as very likely indeed to happen, virtually certain to happen, and they press on nevertheless? Well, after no fewer than 4 visits to the House of Lords, it was finally settled that somebody could be guilty of murder if they intended to kill or cause grievous bodily harm, and that a jury can find intention if the defendant foresaw the consequence as a virtual certainty. So there is a threshold. You can find intention, members of the jury, but you can only find it once you've got over a threshold that the defendant foresaw something as a virtual certainty. That's for the principal committing the murder. That's for the person who plants the bomb. That's for the person who shoots from actually planting the bomb is the best example. I wasn't sure whether it would go off. I wasn't sure whether anybody would be in the building or not, but I saw it was pretty likely because it was a busy time of day and it was a shopping arcade and so on. Well, how do we square that with what's happening in Joji? Because in Joji they say you have to have intention, you can find intention from foresight, but then the Supreme Court never goes on to put that threshold in place. There's no requirement to say you can only find foresight sufficient to ground intention if the foresight was of a virtual certainty. So a threshold that applies in relation to the stabber or the shooter or the bomber doesn't apply, it seems, in relation to the assister. That's quite difficult to rationalise in terms of legal theory. Why should the intention differ in that way? It's also difficult in practice, of course. What are you to say when you've got 2 defendants in the dock? Well, members of the jury, when you're considering this defendant's liability, he's the character who actually planted the bomb, the test is whether he intended it or not, and you can find intention provided he foresaw the outcome as virtually certain. When you consider the chap next to him, who's the character who drove the getaway car to plant the bomb, then you have to discover whether he intended to assist the principal. You can find intention from the fact that he foresaw that the principal might commit that offence. But no threshold is imposed. Worse still, what do you do where it's not clear who was the driver and who was the planter? Which test do you apply in relation to which individual? So work for the Court of Appeal. Also work because if the judges don't all give the same direction on this, if some judges say, oh, well, I'm going to say that the secondary party must be found to have intended, and I'm not going to say anything about that foresight stuff. Ormerod had whittled on for so long by then that I didn't really understand that. I'm just going to say intention. Fine, that's what the Supreme Court says, but the judge in the room next door may well have stayed awake for long enough and add on the lines about foresight, and then we've got inconsistent jury verdicts on identical fact patterns. Will juries be up to the task of drawing those kinds of distinctions? Will the Court of Appeal be able to resolve them? Just a few more problems. I'm conscious that I'm running up against time. Knowledge of weapons. How much has really changed here? Again, the decision in the Supreme Court looked to offer so much by removing the requirement, or by expelling this requirement of mere foresight. But actually, it seems to be a very slight change when you consider that a knowledge that the principal had a weapon is still going to be very strong evidence indeed of foresight, and foresight itself can lead to intention. All we've done is move from substantive law to intention. So in my scenario, I drive off to take you to the rival drug gang's den. If I know that you have a weapon and know that you have a knife, it's a very slight change from the old law, because the jury will be invited to say, well, from the knowledge of the knife you can infer that the defendant foresaw that the principal might do this, and from that you can infer that he intended that the principal might do this, and that's sufficient for liability under Jody. Despite the Supreme Court using the term intention no fewer than 50 times, I think, in the course of the judgment, they never really spell out precisely what that term means. And if you look at some judicial statements, like this one, which is endorsed by the Supreme Court from Mr. Justice Devlin, it looks like something akin to indifference might constitute intention. One man deliberately sells to another a gun to be used for murdering. He may be indifferent as to the outcome, and yet that would be a sufficient intention for murder, said Mr. Justice Devlin, as he then was, and the Supreme Court endorsed that. So we really do need, I think, for the Court of Appeal to refine precisely where the boundaries are. I'm just going to skip over that. It's a very technical point, and I want to keep some people awake. A greater jury burden. All of that I've described in relation to foresight and knowledge and so on means that jurors have a harder task. Under the old law, if I call it that, they were told, if you find foresight, that makes him a murderer. Take it from me, you might not like it might seem wrong in policy terms, but that's the law, he's a murderer. What they're now told is, you must find intention, and you can find intention from foresight, and that's something for you to consider. It gives the jury more moral elbow room, you might say, looking at it in a positive light, because the jury can distinguish on the facts of the case where they think the moral boundary of murder might lie. Looking at it in a less positive light, you might say that the jury are being given the discretion to describe and define the boundaries of murder on a case-by-case basis, unless we know precisely where that definition of intention lies. Just a couple more concerns I have. It really is uncharitable, isn't it, of me to do this. But here's another one. You remember earlier I described the get-out clause. Well, I've gone along and I've driven you to the burglary. I never foresaw that you were going to have the machine gun there. I thought you'd have a knife. So the manner of your killing of the individuals within the rival's gang den takes me out of the equation. That doctrine, that escape route, is no more. If you look at the decision, it seems to have been removed. It's no longer necessary, because the liability, my liability, turns on my intention. But then the Supreme Court slips in an equivalent. They say, but of course, the defendant might escape liability for murder where the principal's acts amount to some overwhelming supervening act. Well, my concerns about that are twofold. In short, I don't know what that means, if it's different from fundamental difference. What does it mean if it doesn't adopt the definition under the old law of what fundamental difference means? And the other problem I have with it is that it imports a causal doctrine. It seems to be cast in the language of causation. This is about breaking the chain of causation. It implies that only when the principal has done something so overwhelming that my involvement is just part of the history that will I escape liability. So the defence, if you like, the exemption rests on a break in causation. But my liability, in the first place, has nothing to do with causation. So there's a real incoherence. My liability is not founded on me having caused the principal to do anything. So why should my exemption from liability turn on whether or not there is a break in a chain of causation? Chains of causation have nothing to do with this. And again, I'm just going to skip over a couple of the examples that I included on that. Final criticism, if I can make it, is on manslaughter. And this really is rich. having said that the pool of murder was so wide that some of the people at the bottom end of murder ought to be shunted into the category of manslaughter, how can I criticise the breadth of manslaughter? Well, I can't really criticise the fact that those individuals who have been taken from the pool of murder and placed into the category of manslaughter. That is exactly what was envisaged by the decision. My complaint is that at the bottom end of manslaughter, the breadth of the offence is quite astonishing. Just as an example, there was a recent case involving two youngsters, two teenagers, one of them with severe learning disability. They'd set fire to a disused sea cadet base, a derelict sea cadet base, and in doing so had caused considerable damage, but also killed a homeless man who'd been taking refuge in there. They were charged with manslaughter as a result of their unlawful act of arson. They were also charged with aggravated arson. And for aggravated arson, it's necessary to prove that they foresaw a risk that somebody would die. They were acquitted of that because their youth and their learning disability meant that they could not have, or did not at least, foresee a risk that anybody would be harmed. They did not have the foresight that somebody would be harmed. So they were not guilty of the aggravated arson offence, but they were guilty of manslaughter because that is an objective test. The question for manslaughter is, having done their act, starting the fire, would a reasonable person have realised that somebody might come to some harm as a result? So it's an extremely broad doctrine. Right, I want to conclude with 2 points. This is probably where I should have begun. What next? What's the immediate future hold? Well, the first thing is something that I can't really talk about at all because a retrial is now pending. So I'm not going to discuss the facts of the case, the likely outcome or anything else. A retrial has been ordered for Mr. Joji. But the more interesting issue might be what happens to all of those appeals out of time. What happens to all of those people convicted under the old law, if I can call it that. And the Supreme Court, in a very carefully crafted judgment, anticipated this. I'm not sure who in the joint authored decision between Lord Toulson and Lord Hughes wrote which parts, but if I was to put money on it, I would say Lord Toulson wrote the first part because it's packed with historical scholarship, and Lord Hughes wrote the back part, which is much more tailored to how am I going to alleviate the concerns of members of the Court of Appeal Criminal Division, where until I was elevated to the Supreme Court, I was Vice President and taking responsibility. So I may be wrong, but I get the sense of it. And this is towards the back end where the court, Supreme Court, whoever it was, is saying not all of these convictions now need to be quashed. Where a conviction has been arrived at faithfully, etc., the individual, the applicant, will have to go back to the Court of Appeal and they will have to make an application out of time. It will be beyond the 28-day period or whatever it now is for an appeal to the Court of Appeal. And the fact that there has been a change of the law, and I keep saying, if I can call it that, because, as you all know, those of you who are lawyers know, in theory, there hasn't been a change of the common law. There has just been a finding of the law. The law was always there. It was just that in Chang Wing Sui we hadn't quite found it properly. The declaratory theory of the common law is such that the law is not old and new, wrong and correct. It's simply being rediscovered. It's been discovered since time immemorial. Lord Reed in the House of Lords described that as a fairy tale, and Lord Nichols more recently in 2005 in the House of Lords described it as at odds with reality. But that's the theory, that's the doctrine. How does the Court of Appeal deal with these cases out of time? Well, the Court of Appeal guards its work carefully. It protects itself quite carefully. It will only grant leave out of time, somebody who's making an application out of time, if there has been a substantial injustice. And simply to have had a change of law is not itself a substantial injustice. So what we have to await is a decision from the Court of Appeal, perhaps as a result of a reference from the Criminal Cases Review Commission, challenging the question, what is a substantial injustice? Well, what are the arguments that can be deployed? The most striking ones seem to me that in many of these cases, not necessarily all, but in very many of these cases, the shift will be from a conviction for murder to what would have been a conviction for manslaughter. Taking a hypothetical case, my case involving the rival drug gang's den visit, whereas under the old law I may well have been convicted of murder, subject to what I said about foresight and so on, if the test of intention is applied as the court intended it, it may well be that I am now only guilty of manslaughter. The query is then, of those cases, there'll be a few cases where somebody has been convicted of murder and applying the new doctrine, they would not be guilty of any homicide offence. But in the majority, I think, there would be likely to have been a manslaughter conviction applying the new law. Is it sufficient to say that there is a substantial injustice because I have been labelled as a murderer? That's a unique stigmatic label. I think everybody in the room would agree. That I've been labelled as a murderer, and of course that's a label that stays with me for life, because even having served my term, I will be on licence for life as a murderer. Coupled with the sentence, and this is perhaps where the court will have to do considerable work, the sentences under Schedule 21 of the Criminal Justice Act for murder are very high indeed. It sets tariffs, so either a whole life tariff, 30-year tariff, or 15-year, and where there has been the taking of a weapon to the scene of a crime with intent to use it, the starting point would ordinarily be 25 years. So a lot of the cases that we're talking about are going to be in the 20-plus year group, even for those who've been the assisters. If you were to convict those people only of manslaughter, I say only of manslaughter, the sentence would be far less. Let's say, depends on the facts, of course, but let's say 15. Well, you might say, well, that's a 10-year gulf. Is that sufficient to constitute a substantial injustice? But it's actually more subtle than that, because the conviction for manslaughter as a determinate term would mean that you served 7 or thereabouts. The conviction for murder with a 20 or 25-year tariff would mean you served 20 or 25. So actually it's a difference not just of 10 years, but a difference of more like 15 or so. So is the label, the stigma, the unique lifelong prejudice you suffer having been labelled as a murderer, coupled with the potential disparity in sentence, sufficient to argue that you have been the victim of a substantial injustice? If it is, then the Court of Appeal may grant leave. If not, then Jogi will really only have prospective effect. It will only take effect in relation to those cases to be tried thereafter. To finish, some really positive messages. I know I've been critical, but that's an academic's role, isn't it, really? You can never be content with the law, or else there'd be nothing to write about. I think it's a really strong confirmation of the common law, prepared to develop, to evolve, and to acknowledge error, to acknowledge that sometimes correction, refinement, and so on is needed, particularly in light of the evidence put before the Supreme Court, of the principled problems, and of those policy concerns. If you look to the Supreme Court's website, you will find that you can watch the hearing, and you can watch the submissions being made, which included those points made about the minority ethnic community and the disproportionate impact, and so on. So a really positive sign, and I think confirmation that the Supreme Court as an organisation, as a body, as an entity, is willing, where necessary, to tread where Parliament perhaps fears. That could be a very good sign. In the face of repeated denial by, or the refusal by the government to step in and adopt Law Commission recommendations, in part because of the timing, in fairness to the government, but despite those refusals, the Supreme Court was courageous enough to take it on. And of course it offers more opportunities. It offers the CPS opportunities to recraft its policy on prosecution. It allows academics and others to monitor the impact going forward. What's the proportion of people who are being convicted of murder or manslaughter, and what are the consequences of that? And it offers me some immediate work with the Judicial College in drafting new guidance for judges on how to tell them what intention might mean. I've trespassed way beyond my time. Sally didn't tell you that I never kept time on any lecture that I ever gave, but you've been extremely patient and I'm very grateful. Thank you.